themselves.
Well, thank you, Sally. Welcome everybody to this session. My name is Chris Priestley, and I'm a partner in the Charities and Philanthropy team at Withers. We're a law firm that advises charities and trustees and have been doing so for very many years. And I'm delighted to be joined by my colleague, Alison Paynes. Between us, we have been advising charity trustees for over 25 years. And so we're delighted today to be working to support our client NCBO in the work it does to help you and civil society more generally. We're both also charity trustees as well, so we look at this through that lens also. So before we begin this session, I just wanted to say thank you. Thank you for being a trustee, for the work you do, and I'm sure at sometimes the personal sacrifices that you make in enabling your charities to make the difference that they do for the public benefit. The sector needs trustees to continue to come forward and to enable charitable support and advice to flourish. And I think it's more important than ever that trustees are supported and indeed valued. These are, without a doubt, very challenging times, and I'm sure for some of you it must feel quite hard and perhaps a constant battle to steer a steady course through these choppy waters. And of course, in challenging times, the work of your organisations is needed more than ever. So what we wanted to do today was to look at what it means to be a charity trustee in the current climate. And we want to remind you of the key areas for compliance, as well as offer a few practical tips born out of our experience of helping many hundreds of trustees comply with their legal duties. Being a charity trustee, I suppose, at times can seem a daunting prospect, particularly as we all grapple with external pressures. We've got climate change to think about at the moment, a cost of living crisis. We're sort of post-pandemic and post-Brexit new order, not to mention a raging war in Ukraine. So whether you are a grant maker, a campaigning organisation, or a service and information provider, or indeed all three, you need to be alive to the duties of your role, as well as the very many resources and organisations that are there to help you with information, guidance and support. You do all, however, operate in a regulated environment. Your principal regulator is the Charity Commission. So I was really pleased to hear the new chair of the Charity Commission, Orlando Fraser, in his inaugural speech, strike a positive note for the regulator in saying, the Commission is not regulating a for-profit sector, but a sector which is by and large a place where wonderful things are being done every day, and where honest mistakes can happen in the process. So rather than criticise an otherwise successful charity excessively for honest and reasonable mistakes, I'll be keen for the Commission to focus on supporting trustees in getting it right when things don't go exactly to plan, as they often don't. I think we all know that things don't often, or quite often don't go according to plan. So what we're going to do in this session is cover off what are the essential duties that you each have as charity trustees, talk a bit about the Charity Commission as your regulator, because it's a changing regulator, and then looking at what we have seen over the years and the current environment, and suggest a few top tips to help you in your role. And then we'll close with some information about the resources that are available to help you. So if we start to look at the essential duties for trustees, perhaps Alison, by way of reminder, you could just briefly explain some of the key duties for charity trustees.
Thanks, Chris. As Chris has said, we're both advisors to charities, but also trustees ourselves. So we need, when we're in both those roles, to keep reminding ourselves about these various duties. And the slide that's just come up comes from the Charity Commission, and it's their principal legal duties by way of a jigsaw. And what we're going to do is go through each one of these in turn. But it's taken together. They really provide the whole framework against which you perform your role as trustee. So taking the first one, it's a question of ensuring that your charity is carrying out its purposes for the public benefit. Sally, could we have the next slide, please? Now, that sounds really obvious because that's what we're all here for as trustees. But during the pandemic, we saw very many charities obviously having to pivot their operations. And now, of course, as funding becomes tighter and costs are increasing and demand also increasing, again, it may be necessary for you to change how you're doing things, and you may be looking to tap into new funding sources. But there is a risk in doing that, that you may have what's called mission drift, that you may be asked, because you're good at doing things, to perhaps to take on something new. It's always important to stop and analyze whether what you're being asked to do is something that you're permitted to do within the scope of what your charity is set up for, because you will have particular charitable purposes set out within your governing document. You also need to be clear who you're benefiting, which is part of whether you have a sufficient range of people that you are benefiting in what you're being asked to do. And considering that in the context of your governing document. And each of you should make sure that you've got a copy of that governing document and you know what it says. And if you can't find it, then you can always ask the Charity Commission for a copy, because they will have a copy on their records. And that brings me on to the second essential duty for trustees, which is actually that you must comply with what that governing document says, and obviously with the law generally. And one of the parts of that is that ensuring that you, as an individual charity trustee, with your fellow trustees, take valid decisions. Something that can be quite easily forgotten is how many trustees this governing document may require you to have. You may fall below that minimum duty, and then technically it may not be possible for you to make a valid decision, and getting that wrong can lead to problems, potential liability. So it's a matter of just keeping an eye on what is said within that document and making sure that you're complying with it. And if need be, you can change most of the provisions within the governing document, but there are obviously procedures to go through to do that. Then complying with the law, clearly exactly which bits of law apply to you, it's going to depend on what you do. But if you have staff, if you employ people, then employment law will apply. If you will be undoubtedly have data that you have, some of that may be sensitive or personal data, and how you deal with that data is affected by data protection law, and then complying with fundraising law, where you raise money from either the public or for businesses. Again, you need to understand the laws that apply in those particular areas.
Thanks, Alison. I think one of the simplest things to remember as a trustee is that at all times, when you are performing your role as charity trustees, you must act in the charity's best interests, what you believe those best interests to be. And that means putting the charity's best interests as you see them above your own, and avoiding any conflicts of interest. I think one of the most common areas where charity trustees can get into difficulty and face regulatory intervention, which is a place you really don't want to be, is where conflicts of interest and loyalty are not properly identified and managed. Now, you might be surprised how often this comes up, so do make sure that you and your trustees declare any personal interests that they may have, and if a trustee does have a personal interest in a matter to be discussed or decided, for the trustees then need to manage that situation properly. And it's usually pretty straightforward, in fact. Usually that will be by excluding the person who has the conflict of interest from the relevant decision making. So that management of conflicts of interest is very important. But acting in your charity's best interest, common sense, of course, that's what you must do. Moving on, you must also ensure that your charity is accountable. And that means staying on top of the charity's reporting requirements. And so where you're obliged to file accounts, get them filed on time. It's important because the Charity Commission's public register of charities, which anybody can access through the Commission's website, actually flags late filings. There's a sort of red flag if you have filed your accounts or annual return late. So again, that's something that you want to try and avoid, because that can put off donors or funders. They may be concerned, and it will also get you onto the radar of the regulator, the Charity Commission, because they will say, well, if you're not getting that right, what else might you not be getting right? So an important thing to be on top of. So we've covered a couple of the essential duties. Alison, do you want to just finish up on the last couple?
Sure. And I suppose we've already mentioned the cost of living, and clearly the current economic uncertainty and the extra burdens that brings highlights the need for charity trustees to manage charity resources responsibly. Now, sometimes this is referred to as the duty of prudence, and it's both keeping on top of your finances, cash flows and financial commitments, and clearly monitoring them as events go by, but it's also about safeguarding your assets. And so something to think about here would be, for instance, do you have adequate insurance in place? And then in addition to the sort of cash and property assets, it's also about protecting your reputation, and safely storing and properly using the data that I referred to earlier. And of course, safeguarding your staff and volunteers. And exactly what will need to be done there will obviously be affected by what your charity does. But in each case, it's important to have the proper controls, procedures, policies, and training in place. And you as trustees need to be overseeing that those things are in place and are being properly implemented. Then finally, as charity trustees, it's a matter of acting with reasonable care and skill. Each of us as a charity trustee brings our own background and knowledge to our volunteer role as a trustee. And so some people, Chris and I, obviously, although we don't act as legal advisors when we are on the board, we come at things with a legal analysis, and you, I'm sure, will all bring the particular skills you have from your own lives to the board. But all of us sometimes need advice. And Chris, as Chris said, we'll be talking a bit later about sources of help and advice and guidance. And also, I think all of us, as Chris said before, things do go wrong, and we need to be prepared for what we'll do if that does happen, and making sure that we know how in those sorts of situations to manage communications and get advice on what steps might need to be taken to mitigate any losses.
Thanks, Alison. And do remember, if you do experience something going wrong, then you might need to make what is called a serious incident report to the Charity Commission. Now, there's really good guidance on the Charity Commission's website about the sorts of things that you need to report and how you go about making the report. But in summary, a serious incident, as the term suggests, is an adverse event which either has actually happened, or somebody is alleged that it has happened, or you think it's very likely that it will happen. And that serious event is going to result in or risks significant harm to your charity's beneficiaries, staff, or others who come into contact with the charity through its work, or it's around significant loss of your charity's money or assets, or serious loss to damage and damage to your charity's property, or harm to your charity's work or reputation. So it's really important that you do report serious incidents to the Charity Commission, not least because when you as trustees submit your charity's annual return, you are giving an undertaking that you have reported all serious incidents that have occurred in that reporting period. Now, there is no stigma attached to making those reports. It's something that is important that you do. And in fact, when I've had discussions with the Charity Commission, they're actually more concerned about the charities where they expect, just because of the nature of the work, there will be serious incidents, and they're more concerned if they aren't getting reports. So it is something just to bear in mind. Now, we've talked a bit about the Charity Commission, and I was interested when I read back that the Commission, in fact, has a very long history, having first been established as long ago as 1853. Now, Alison, I know you've been working with the Charity Commission for a bit longer than I have. How do you think it's changed in recent years, and what's relevant for trustees to be aware of?
Well, I don't quite go back to 1853, but it has been a while. I mean, the Commission is funded by the government, and as you can imagine, it doesn't feel that it's very well resourced, and at times it can be a bit slow but not always. And it has a really interesting dual function. It works both as the sector's friend and advisor, and as its regulator, its policeman. And there is an inherent tension for the Commission, I think, in that role. It is independent of government, although government funded, and it is accountable to Parliament. It can enable charities to do things. So it can, for instance, grant orders, giving charity trustees powers that they may not otherwise have. And going back to what I was talking about earlier, it can approve changes to charities' constitutions, so to changes to the charity's governing instrument. But it also, and this is clearly the regulator side, it can take action against trustees, remove them from office, issue official warnings, intervene in the way the charity is being run. And so it has those two functions. And it has changed over the years. It is now, I think, stricter in its approach, but it's also very keen to provide more information for charities and to make that readily accessible. And much of that information, indeed these days, pretty much all the information, is available on its website. So one of the real resources that is available to you is the information which the Commission has on the website, its website. And it has been trying to make it easier for charities to access that, recognizing that trustees are all volunteers who have busy lives. For instance, they've produced recently some really user-friendly 5-minute guides and videos on various things. The slide here is showing what they cover, and you may recognize that we've touched on quite a lot of these things in what we've just been saying. And so there's more information on the topics we've been covering in these 5-minute guides, very accessible, very useful. And perhaps, Chris, you would like to pick up on what else?
Thanks, Alison. I think that yes, the Commission does have a lot of useful information. Sometimes it can be a bit hard to find, but hopefully the signposting of those 5-minute guides is really helpful. The other thing I would just mention that I think is relevant to you all as trustees is the Commission is starting to ask for a bit more information from you. There was a recent consultation on the Charity Commission's annual return form, and I think what surprised us is the quite dramatic increase in the amount of information that will be asked. Now, depending on what you answer in that form and depending on what you do, different drop-down things will come through. But I think the direction of travel is to ask for more information. And I know that's been unpopular just at the time when people are struggling with all you have to do as trustees to have to provide more information can be a bit painful. I think the regulators doing it because they want to know more about what's going on in the sector so that they can tailor their guidance and support effectively. And the only way they can do that is to get more information from you. The other point on that is, of course, that more information is actually going to be made publicly available. So the public will be able to find out more about what you do and how you operate. So I think that's just something to bear in mind. So I'm conscious we've covered quite a bit of ground already, and I know that for some the prospect of being trusteeship can seem daunting, particularly when there's so much going on in life that makes that role harder. So one of the things I wanted just to touch on, and one of the questions we get asked a lot about, particularly by people who are thinking about being trustees, is the potential risk of personal liability. And I know that Alison and I, certainly, when we're talking to charities, we want to be reassuring on that topic because we need people to come forward to be trustees. Cases of charity trustees, the vast majority of whom are, of course, volunteers, cases of charity trustees being found personally liable are relatively few and far between. And in those cases where trustees have been found personally liable, or in fact have been disqualified from acting, are where they've acted so badly that they really should have known better, and it's the right outcome. Like, for example, you probably saw in the press the other day, the charity trustee of the charity ordered to repay £117,000 of funds that had been misused. Now, this was a cancer charity, and they'd used that money to support the creation of a Welsh dragon statue as a tourist attraction. Not the most sensible of things to do. But just on that theme of personal liability and protection for trustees, Alison, can you just comment on a couple of other areas of comfort that I think there are for trustees?
Yeah, well, if you're acting properly as a trustee, then obviously you're entitled to use the charity's funds to indemnify you against things you've committed to do on the charity's behalf. Clearly, using a cancer charity's money to build a dragon statue couldn't fall within that. But normally, you would be entirely entitled to pay for things out of the charity's funds where they're properly being, it's an obligation that's properly being incurred on behalf of the charity. You're also allowed to take out insurance, what's called trustee indemnity insurance, using the charity's funds to pay for that, to protect you and your fellow trustees against liability that you incur in your capacity as a trustee. Then if something goes wrong and that doesn't work, there is you're at potential risk. The Charity Commission, or indeed the court, but usually the Charity Commission, does have the power to, after full facts are disclosed to it, to relieve you of that liability. And finally, the new chair of the Charity Commission, whom Chris mentioned earlier, Orlando Fraser, he was recently asked about this, and he made a much more reassuring statement than some of those which have come out of the Commission in its regulatory capacity before. And he said that he expected the Commission to be proportionate and wise in its regulatory response to problems and concerns in charities. He went on to say, "We will not come down hard on trustees who make honest, reasonable mistakes. We will remain mindful that we are regulating a voluntary sector run by people overall with good intentions who are doing their best in often difficult circumstances." So I think that approach from the top is a helpful source of reassurance
Yeah.
to trustees.
Yeah, and as I said, we need people to come forward to be trustees. So the last thing you want is it to be something where there is significant risk of liability. So the whole point of this presentation and the guidance that's out there is to make sure that you are able to do the job without worrying about that. Another tip born out of some of the difficulties that we see when things have gone wrong is making sure that you keep adequate records of your decisions and any delegated authority that you've given to others. One of the first things that any regulator will ask if they're engaging with you is to have evidence of the information trustees were given and what they decided. Now, I know it's a real bore to have to prepare minutes and do all that, but it is really important. And the time invested in doing so will really pay back in terms of providing an audit trail and record, which of course can ultimately protect you. And similarly, if you're a trustee of a bigger charity with a committee structure, make sure there's a clear written record of the delegated authority or terms of reference, because whatever is being decided under that delegated authority, that is still an action that is taken under your watch as a board of trustees and for which you retain ultimate legal responsibility.
Yes, and on the question of legal responsibility, a really important thing, which we touched on earlier, is keeping an eye on the charity's finances, because I know many organisations work on quite narrow margins, and at some point, many of us find that the charity that we're involved with is in financial difficulties. And you need to be able to understand that and recognise when there is a possibility that the organisation is facing serious financial difficulties and get advice. And this is because it is possible at that point to break the law even while you're trying to do the right thing. If, for instance, you're doing what's called trading whilst insolvent, and getting advice early means that you're much more likely to be able to develop an effective recovery plan, or if need be, a managed closure. Now, Chris, aside from these sort of practical tips, what else do you think trustees need to be aware of?
Well, I suppose one of the things that keeps us lawyers busy is the fact that the law is constantly changing, and whether that's employment law or data protection law, or indeed charity law. Now, I'm sure many of you will be aware that a new Charities Act was passed earlier this year. And that act took a long time to come through, but the purpose of it was to try and make running and operating a charity easier in many ways, because we know there are lots and lots of rules to have to navigate. And I thought I would just mention a couple of the special rules that apply to charities, because just being aware of them, I think, is helpful, because it may then trigger the need to just get some further advice or look at other resources. And so there are special rules around the use of land held by charities. So if you own land, or if you lease land and you want to sell it or enter into arrangements with that land, there can be special rules that deal with that. So but do bear that in mind. Alison mentioned earlier, if you want to make certain changes to your governing document, like changing your charitable purposes or seeking to pay one or more trustees simply for being trustees, not for any services that they've provided, but you want to bring in a paid trustee, those are the sorts of things where you will need to go to the regulator. Now, that whole area is quite detailed, and it depends very much on the legal form. There are different rules for charities that are unincorporated, like charitable trusts, and different rules for companies and charitable incorporated organizations. We did a seminar on how you go about amending your governing document with NCVO, so that's on the NCVO YouTube channel. The law is going to change in that. That's one of the areas that the Charities Act is going to try and change and simplify and make a uniform set of rules, regardless of what type of charity you are. But I'm afraid that isn't going to come in for at least another year. So if you are going to change your governing document, do have a look at that guidance and that video of the recording of that session. There are also special rules if you want to engage what's called a professional fundraiser. So somebody who you want to pay to fundraise for the charity, the rules around the disclosure statements that have to be made to the public. There are also rules that specify that you must have a legal agreement in place if your charity wants to partner with a business, a for-profit organisation who's going to fundraise for the charity. There are also some rules around political campaigning, and there's one of the 5-minute guides on that. That's going to become far more relevant in the run-up to the next general election. Charities can, of course, get involved in advocacy work and campaigning, but they must do so to further their charitable purpose rather than supporting any single political party. Having a political purpose is not something a charity is permitted to do. And then the other area that crops up is particularly around appeals and money given to you for a purpose that falls within your purpose, for a specific thing that the donor or your appeal ask has requested. And that means when that money comes to you, you hold it as what's called a restricted fund, and you must apply that money for those restricted purposes. And so there's special rules around how you can use money that you've raised if it's, for example, over and above the amount of money that you needed, or indeed if you don't raise enough money. And again, there's some good guidance on the Charity Commission's website. So those are a few of the sort of common areas where there are specific rules that are relevant. The Charities Act, the new Charities Act, doesn't abolish any of these rules, so it's important that you are aware of those key areas. What the Act does do, as I say, is going to simplify how you're able to amend governing documents, but that will take a while to come through. And there are also going to be some changes around charities who do dispose of property, land that they hold. Then it's going to be slightly easier in terms of the people that you need to get to advise on whether or not the disposal is achieving best value. Now I'm going to hand back. I'm conscious of the time. I want to leave some time for questions. So I'm going to hand back to you, Sally, and to talk a bit about the resources and the support that's available.
Thank you so much, Chris and Alison. That's been a really fantastic overview of all of those really key elements that we need to be mindful of as trustees, and we're very grateful. There's some details here on the slides. I can see lots and lots of people are saying that they'd like copies of the slides. You will get all of our materials from this session and all of the other sessions that are part of our Trustees Week series as a follow-on from the programme this week. And we do have lots of other resources as well. So through the week, we have got several more sessions for you. Tomorrow, we're talking about setting direction and creating strategy. On Wednesday, we've got a session all about those tough conversations which trustees may need to be involved in. On Thursday, we're picking up on how you find the right skills for your board. And then on Friday, we have an amazing panel discussion about learning and development. And we also have a wealth of help and guidance resources, which are available to you on our website. And I've just popped the link into the main chat. Now, we've got a bit of an opportunity to look at a couple of your questions. If anyone does have additional questions, you can still add them into the Q&A. I've answered a few in writing, but there are a couple that came up I thought would be really interesting to ask Chris and Alison. What I will do is I'll stop sharing the slides so that you can see us all. And I'll pick up on a question which I think will be a quick one to answer, but it's one that I know we get really regularly, which is from Oliver. Oliver asks, how often do we need to declare conflicts of interest? Should it be every meeting, annually? What are your thoughts?
Well, shall I go first and then Chris can always comment afterwards? The point about conflicts of interest is that they affect whether or not you can make a decision objectively. And so it's important always to have this in mind. Every year, there needs to be an annual declaration, which is what I suspect Oliver's thinking of, an annual declaration, which the auditors will expect to see of where you have an involvement with an organisation that perhaps your charity deals with. But actually, at every meeting, there needs to be an inquiry just at the beginning. Anyone looking at the business on the agenda, anyone got anything they want to say about this? And it's just really good practice to mentally to sort of scan what you're going to be talking about and whether you have anything, whether professionally or personally, that might mean that you can't properly be objective about it because you've got another interest, whether, as I say, personal, professional, family, or whatever. I don't know, Chris, whether you've got anything to add to that.
I think that's absolutely right. It's you always have it in your mind that, you know, the point of having that annual sort of register is to sort of pre-screen things so that you can manage. So you wouldn't, you know, you would know in advance, oh yes, X is involved in that organization we're about to work with, so they've got a conflict of loyalty. But you know, the annual declaration is just something that's a snapshot in time. So it's always incumbent upon trustees, just when they're looking at the agenda, if there is something, think, oh, hang on a minute, I actually am interested in that, so I better tell you. And then the other trustees manage how they deal with that situation. It should be relatively straightforward.
That's great, thank you. And we've got a couple of related questions that I'm keen to pick up on. That have come through. The first one is from Gillian, who asks, is trustees indemnity insurance still necessary if the charity is also a limited company? And then just connected to that, there's a question around the difference between being incorporated and non-incorporated. I wondered if you could elaborate on that difference for us.
Okay, well, let me do the second question first in terms of the difference between being incorporated and unincorporated. And again, there is a seminar on that, a webinar rather, on the NCBO channel about choosing your legal structure, which is looking at it when you set up a charity and deciding, do we want to be what legal form? So that will be relevant. But in simple terms, having a corporate entity is perhaps more common now than it used to be, but it means that there is a separate legal thing that is different from the trustees. So that means the charity, which will either be a charitable company limited by guarantee or a charitable incorporated organization, is what's called a legal person. So the charity can enter into contracts in its name, and something that's come up in one of the other questions, it means there is limited liability. So if something goes wrong and somebody is going to bring a claim, they bring a claim against the charity as an entity rather than the individual trustees. Now, it's quite a complicated area. There's lots of guidance on the Charity Commission around insurance and trustee indemnity insurance policies. But the specific question, I think, was, do we still need to get trustee indemnity insurance if we're a limited company? Yes, it can still be very helpful, because trustees personally may want to get separate advice on something about their own position rather than the position of the charity. And so that's the sort of area where trustee indemnity insurance will be helpful. If it's helpful, there are lots and lots of charities who don't have it and have never had it, but there are some that do. I suppose if I was to say there is a trend, probably a trend slightly to more people having it, but I say there's lots and lots of guidance on the Charity Commission website about the sorts of insurance charities can take out.
Yes, the one thing I would say about trustee indemnity insurance, and I think there's been a question about whether that's different from directors and officers insurance. If it's a company limited by guarantee or a charitable incorporated organisation, D&O cover would be what you'd be looking at, but it's very important to make sure in discussion with the insurance brokers or whomever you're getting it for, that what you're getting is appropriate for your charity, because ordinary D&O cover might not take account of the particular charity risks. So it's worth going to an insurance broker who understands what trustee indemnity insurance in the context of a charity is.
Thank you very much. I've got another theme coming up in our questions, which is going back to the question of conflict of interest, particularly looking at the legal obligation around how we manage services or skills that are provided by a trustee or by their attached organisation, and how to manage that conflict. So I have a question on that. What is the legal obligation for using services of a trustee? And then in addition to that, can a paid CEO be a trustee? So that's a different type of payment for skills. What are your thoughts?
Shall I take the first one, and Alison, you'd be happy to take the paid CEO?
Yeah, sure.
Okay. So the question about managing conflicts of interest where a trustee might provide services, or a business related to a trustee might provide services, it's a really good one, because it picks up two of those essential duties of trustees. One, the duty to avoid conflicts of interest, and the other one around acting in the charity's best interests. So if there is a proposal, if the charity needs to buy in a service and a trustee is able to provide that service either personally or through a business or some other connection, then that might be brilliant, because they will probably know a lot more about the charity than anybody else. But you need to make sure you're getting a good deal, and you need to make sure that that trustee isn't involved in the decision, because they have a conflict. It would look terrible to the outside world if they were deciding on their own position, because they're going to benefit from it. Now, the governing document of the charity will talk about trustee benefits, and there is also a statutory power that enables trustees to be able to be paid, in other words, benefit out of the funds of the charity personally, if they're able to provide a service. But you've got to pay for something. So you're paying for value coming into the charity through the provision of that service. And you need to look at whether or not is this trustee, or the business that trustee is connected to, is that the only show in town? Is that the best provider of that service? Yes, it's great that they want to do it, but we've got to act in the charity's best interests. So are they, have they got a good track record in providing this particular service? And are we paying something that's reasonable and fair? Can we look at perhaps what others might have charged, and are we getting a good deal? And of course, all of that discussion and then decision making has to be taken in the absence of that particular trustee who has that conflict of interest.
Then the query about the chief executive being, who's obviously paid for that role, being on the board. One of the differences between a charity and, for instance, a commercial company, is that the board is expected to be entirely volunteer. In other words, not to be and not to receive any remuneration. That's the sort of starting point. Whereas obviously with commercial companies, you often do have both the chief executive and the finance director who are executives, both of them on the board being paid. The starting point, however, for charities is that there's a wholly volunteer, non-remunerated board. If therefore there is going to be someone on the board who is being paid, that would count as a trustee benefit. And the particular position of the chief executive being on the board would have to be authorised either by the governing instrument already or by the Charity Commission specifically. And so it is something where both Chris and I have, on behalf of clients, have contacted the Charity Commission and made out a case for the chief executive of an organisation to come onto the board, but it is something that has to be specifically justified in relation to the circumstances of that charity, and then get specific authorisation, as I said, either by order from the Charity Commission, or if the discussion was had, for instance, when the charity was set up, there may be a provision in your governing instrument which authorises it, but it is unusual.
Fantastic. Moving on to a slightly different topic now. We have another question from Oliver, who says, on political campaigning ahead of elections, if we don't know when it will happen, how can we know when to change our actions to comply?
That's a very good point. I mean, I suppose that the political campaigning guidance is relevant at any time, because, you know, if you're campaigning or advocating for changes in legislation or rules, then that's that applies whenever. There are special rules that do apply in the period in the run-up to a general election or local elections or a referendum, and usually you'll get an announcement from the Charity Commission reminding people of that period. Now, if you think a general election, from the minute it is called, notice of the poll has to be given, and so there are rules at that point. So all of that is in that political campaigning guidance. So there are, I think it's just, you know, if you know that there is a general election coming because the election has been called, then I think that's the time to look again at that guidance and see the specific rules that apply in the run-up in that election period. But generally, charities can, of course, campaign, and they can, of course, advocate for changes in legislation, as long as that's connected to their particular charitable purposes.
Yes, it's got to be in fulfillment of their charitable purposes, not as an end in itself. So you need to be very clearly able to tie it to your beneficiary group, to what you're seeking to achieve for them, for instance.
Fab. We're coming towards the end of our time, but there's one more question I'd really like to pick up on. For anyone who's asked a question that hasn't been responded to, I'm going to try and type in some answers before we finish, but you can also find lots and lots of support with all of these issues on our help and guidance pages. So the final question that I wanted to put to you both for this session, we had a query about organisations who are not charitable community organisations and whether there are regulations around those, as well as the relationships between charities and non-charitable organisations. Now, in the answered panel on the Q&A, I've shared a link to the Charity Commission's guidance on charities working with non-charitable organisations. But Anne's followed up just by asking, could you talk a little bit more about corporate charity partnering with a for-profit organisation and the issues there, which I thought would be a nice, interesting point to end on.
Okay. Shall I give just a couple of comments, and then I'm sure Alison will have others. But I think in terms of being a charity, you are an independent thing. You can't own a charity. You exist for charitable purposes. So you must act independently. So when you're partnering with business or any other organization, it's always about protecting your independence and making sure that whatever arrangement you have with that organization guards your independence and doesn't mean that you are doing something just to help the business. It's got to be about what's helpful to the charity. And there are special rules if you are the beneficiary of a fundraising campaign, a promotion. You know, the big supermarkets, you'll have seen all of those promotions sometimes where they are representing that money is going to go to charity from some of the business activity. There are very specific rules that talk about a legal agreement being put in place between the charity and that and the business. That's to protect the charity, to make sure that its interests are protected and that you get the money that you're being promised under that promotional activity. So there's a fundraising element, and then there's also just any arrangement or any working with a business. Are you protecting the charity's interests? And have you thought about the reputational risks? Is this a business that you're comfortable with being associated to? And does that reflect well in terms of your own values and what you say you're about?
Yeah, that last point was one I was going to raise as well, that you need to think. Quite often charities are approached and it looks as if it's going to be a really good deal for them, but is the organisation that you might be partnering with in whatever way one that we sometimes refer to the Daily Mail test, you know, would it stand up to examination? And sometimes it's not terribly obvious. I mean, we had a charity associated with the NHS, which was offered quite a lot of money from a company that manufactured fireworks. And obviously the choice for them in that case, it wasn't terribly obvious initially. But clearly fireworks, as we, you know, given we've just gone past the 5th of November, that may be why it's in my mind, you know, people are often injured by fireworks as well. Was it an appropriate thing for a charity associated with the NHS to be taking money from? That sort of thing. You need to think it through. Another thing is, if you are partnering with a for-profit company, you need to assess whether what you, and that doesn't, I didn't mean so much there in fundraising terms, but if you're doing, say, a joint initiative together, are you in any way using your charity assets to benefit that for-profit company? If so, how is it structured? And is too much benefit going to that for-profit organisation rather than coming to you? So it's a matter always in these situations of sort of thinking it through from a number of different angles.
Fantastic. Thank you ever so much, Chris and Alison, for your time and for sharing your expertise with us. And thank you to everyone who's attended this session for your thoughts and your very, very interesting questions. Don't forget, we do have further sessions coming up for the rest of the week. So just another reminder, we've got strategy tomorrow lunchtime. We've got some stuff on having those more difficult conversations as trustees on Wednesday, how to get the right skills on your board on Thursday, and then a learning and development panel discussion on Friday. We also have lots of resources available on our website, and you can go to the Trustees Week website to see more on what other organisations in our sector are putting together for the benefit of our big, wonderful community of trustees. Thank you very much for being part of our session today, and I look forward to seeing you all through the rest of the week.
Thank you. Bye.